because the topic that has been given to me is actually the rights of the woman post marriage. Actually, I'll define it that I'll define that topic as rights of the woman in a domestic relationship. Now, see, we have been discussing as a society, as a legal fraternity, we have been discussing rights of the woman on streets. We have been discussing the rights of the woman on workplace. We have been discussing the rights of the woman in employment and every other aspect. But now there's a very important aspect, very peculiar kind of necessity is there to discuss the rights and safety of women at home. Now, this safety of women at home has certain very interesting connotations. Firstly, a woman may not be a part of of the workforce. She might not have a place of employment. Secondly, she might not be a woman who actually roams around the street, goes to educational places, or who have not much exposure from outside world. There's a huge population of women in India who are uh, facing problem in their own domestic circle, in their household, where we need to protect women first. A woman is born, she dies, she is always involved in domestic relationships. And those domestic relationships, maintaining those domestic relationships, nurturing those domestic relationships, are considered primarily the responsibility of the woman only. It is considered the primary responsibility of the woman to nurture those relationships. She as a mother, she as a wife. Mostly the society views that okay, this is the woman, and she has the responsibility of maintaining the relationship, maintaining the family, protecting the bond of the family. Whenever family breaks, people blame women. Family is well united, well integrated. People actually give credit to the women of the family as well. Now, that being the case, where the majority of the life of a particular woman is spent in her domestic sort of setup, we need to discuss the rights of a woman in domestic relationships, not specifically marriage, because that right should be available against everyone else who is there in the family of the woman, and not specifically men. Why what I am discussing is different from all other various topics that we are going to discuss later in this course is the rights of the woman at workplace, at streets, in criminal law, everything that the opposite party is a man. So it's based on gender binary. But when we talk about domestic rights of women in domestic setup, we also include the relationship or the opposite party, the respondent, the threat to the autonomy and freedom and life of women might come from. Give me a second, please. I'm so sorry. I'm so sorry. Okay. So what I was saying is that that particular woman, when she's in a domestic relationship, uh, then obviously she does not interact with men only. She interacts with women, fellow women in the family, and more often than not, the trouble or the threat to her freedom, life, limb, liberty comes from another woman. So that is one of the aspects that we have to discuss. So I'll simply the protection of the woman that has been granted by law. I'll simply divide it into three parts. One is protection given under criminal law, that is the provisions of 498A of IPC, erstwhile IPC. You can definitely refer to the new section in BNS, but that is a section of IPC which has not been changed much. It is as it is in BNS as well. So that is the first aspect. Second aspect is the right of a woman in family law, the right to take divorce, right to seek maintenance. Those rights are there. And thirdly, the right of the woman under a very specific or particular law, that is protection of women from domestic violence act 2005. That right is apparently looks like a criminal legislation, but is not actually a criminal legislation. It's a civil remedy based legislation, and that remedy is not particularly based on the family law. Civil remedies that are there in family law, but the Protection of Domestic Violence Act is a very unique is a sui generis legislation. So we'll discuss all three. So we'll get a basic idea that how a woman can protect herself, what are the rights given to her by law, and how a woman can protect herself in a domestic relationship. Firstly, coming on to the criminal law setup, we all are familiar with 498A. There is much hullabaloo about its abuse sometimes. The Supreme Court in many cases have used the guidelines and all. But the criminal law part of protecting a woman, that is 498A IPC, simply states that if a particular woman is subjected to cruelty by any of the relatives. Now here again the distinction between the husband and the other relatives of the husband is not there. While a woman can file a case against her husband alone, she can file a case against her husband, other relatives, as well she can ignore husband and file the case against other relatives only. Mother-in-law, father-in-law, sister-in-law, whosoever she wants to file a case, she can file if she has been subjected to cruelty. Now, cruelty is a very interesting term. Specifically in the case of criminal law, cruelty does not refer only to the physical harm or threat of the harm to life and limb of the woman. It does not require that somebody should physically harm a woman. But at the same point, our jurisprudence have evolved that we are now including in the definition of cruelty mental and financial cruelty. See, there are n number of cases which define cruelty, which says that inflicting pain on the woman or making such circumstances, creating such circumstances which will actually force a woman to commit suicide or harm their life and limb or make her life miserable, everything. But to my understanding, cruelty has only one meaning. Now, you might say that it's oversimplification, but I believe that definition is restricting the choice of woman in a household, not giving her the same choice as her other members of the family is cruelty. Very simply stated. If other members of the family has a particular choice, if her husband has a particular choice, and she is not given that choice, she is not given the same autonomy, then I believe it's cruelty. It's violation of the equality in the household. One might say that the equality is a constitutional setup term, but no. A truly prosperous home is an equal home. Equal home means all the members of the family enjoy the same degree of autonomy. If somebody else has an autonomy, then it's not an equal home, it's a violation of rights. Simply, the most obvious example of it is that if a particular person is there, he gives more autonomy to his son and gives less autonomy to the daughter. I believe that is cruel to the daughter. You should give same rights, same duties, same autonomy, same choices to both boys and girls if you have children. So at the same time, the husband, whatever autonomy he takes for himself, like suppose he has autonomy to work, he has autonomy to work late, he has an autonomy to mingle with other from the colleagues from other whatever husband takes, suppose he has autonomy in husband can spend money as he likes. Same autonomy should be afforded to a wife as well. Same autonomy. No member of the family should live at the mercy of the other member. Specifically, that she should have same rights as her male counterparts. For example, obviously a woman might say, you see, my husband has an income of, let's say, 50,000 rupees a month and he's not taking me to five-star hotel. This is cruelty. But it's not cruelty, because the luxury of going to five-star hotel is not available to the husband either. Husband is not going to the five-star hotel and he is saying that my wife, I do not have money to take you as well. I am not going, so you are not going. So this is not cruelty. This is equal treatment, and that is fine. But if a husband is suppose has an annual income of 1 crore rupees, then he's saying, I will go to the movies, I will go to the hotels, I will go to the expensive fine-line restaurants, and I will not take you. You are not allowed to do so. So now that becomes a problem. That becomes a cruelty. So sometimes when we see the dowry cases, no, domestic violence divorce cases, when the court said that I am giving you divorce because the husband is not, how this is a ground not taking on a vacation, why this is a, how this is a cruelty. The point is not going on vacation. Point is equal treatment. If some privilege the husband is taking, same privilege he should extend to his wife as well. So that is the 498 standard of cruelties. So that is something that we have to keep in mind. That equality in marriage is something that is very important. Same level of freedom, same level of choice. So that right, even a daughter can ask from her father. And ideally, there is no right behind it. But nonetheless, there should be. Then we will actually make capable people, will make assertive women, will make equal, will have equal representation in our society. Secondly, let's talk about some family law aspects. Now, family law aspects, the first right a woman has got is a right to maintenance. Now, any woman in a particular domestic setup, she has a right to be maintained by the provider of the family. Like a woman, the wife has a right to claim maintenance from her husband. And there's a very leading case, Rajneesh versus Neha, which you might have heard. Supreme Court has very categorically said that a woman is entitled to get maintenance from her husband, and similarly, a daughter from her father or mother, a woman from her son or daughter. See, if the law is intended to prohibit, or the law is intended to avoid destitution of a woman should not be, um, she should always be supported. That's the legislative intent. So she is entitled to get maintenance from all the relatives that she has. She can maintain from her father, from her husband, from her son, whatever the case may be. Even from the daughter, she has the right to get maintenance. Now, given having been said that, the maintenance is generally governed by the personal laws of the parties. A Muslim law is there, then there's CRPC, that is BNSS now. BNSS provision is there 144, I believe that provision has become the provision of maintenance. And then we have in Hindu law we have provisions like Hindu Adoption and Maintenance Act. Then we have provision of maintenance under Hindu Marriage Act. Then we have under Muslim personal law also the provision of maintenance is there. The Christian law also provides maintenance. So right to the maintenance is there. There is universally maintenance. The right is there. And the another question is again how much maintenance. We keep on seeing reels on Instagram that the wife is asking crores of rupees as maintenance from the husband. Sometimes the judge is furious that how you can ask so much of maintenance. Now see, sometimes even the judiciary also fails to understand the logic, and they seem to forget the principle of matrimonial parity that I have been emphasizing earlier, that I emphasized earlier. There is something called matrimonial parity that must be understood. When I say matrimonial parity, it means that the wife is entitled, if she is living apart from her husband because of any genuine reason, she is entitled to get the same amount of maintenance that will allow her to maintain the same lifestyle that she had when she was together with the husband. And she must enjoy, she will be given the right to enjoy the same lifestyle, same amenities, same facilities, same privileges as her husband enjoys. That's why the maintenance is flexible. Even if the maintenance is fixed, and a particular woman says that, okay, my husband is now earning, he was earlier earning 1 lakh rupees, now he's earning 5 lakh rupees, so my maintenance should be increased, then the court is bound to increase her maintenance to match her lifestyle with her husband. So the first thing is the right of maintenance, and under that right, there is concept of matrimonial parity. Same right is given to the mother when she's asking the maintenance from her son or daughter. Same right is given to a child. If a woman is seeking maintenance for her child, or a child is seeking maintenance from her parent, he is entitled to enjoy his. There is no concept of starving maintenance. And if my suppose I'm a child and my father is living in a posh bungalow and all, if Taking example from a very legendary movie, several Oscars it has won, Suryavansham, you must have known. So if the father is living in a posh building and all, and son, although that son being 18 years of old is not entitled to rent maintenance, but for the sake of argument, let's say son is living like a servant. That is something that's not intended by legislation. Legislation intends to have parity in the family. That is why whosoever is entitled to maintenance, how much in maintenance they're entitled to, that the maintenance they are entitled to is the same amount that will allow them to live in the same way as the person who is giving maintenance lives. If the person giving the maintenance has a big house, has lots of cars, same facility, same type of amenities should be even given to the other person who is seeking maintenance because he's a member of the family. That is obviously the logic. Sometimes courts allow their own morality in that. I've seen judges; they are very hesitant. They are saying, "Oh, why you can live in 50,000? Why you are asking 2 lakh rupees if your husband is earning 5 lakh rupees?" Yeah, one person can survive in 5,000 also. But that is not the point. The point is not to survive, but to live just like they were living before. So there is very important aspect that we should, the judiciary, the advocates, everyone, even society, we should not actually blame the women when they are claiming equal rights in a matrimonial home. That will be most unfortunate. That will be improper. If they are actually, if we are attaching a stigma to it, no. Those who are entitled by law should have every legal as well as moral right to claim that. That is very important. Right to maintenance is considered a very important right. That's why so that the right will not be frustrated by judicial delay, we have the provision of interim maintenance. That as soon as the petition of maintenance is filed, interim maintenance is generally granted. If the prima facie case is established, interim maintenance, the court starts immediately. Furthermore, the maintenance from the back date is also given by the courts. Sometimes there is intentional delay tactics by the husband or whatever the case may be. There is delay tactics used. So in order to counter those delay tactics, the amount of maintenance goes from the date of the filing of the case, not from the date of award. So that is also a very interesting aspect in relation to maintenance. So even if you have delayed it for a year, and suppose the person who is claiming the maintenance, the woman is seeking money from, she's borrowing money or she lived in a very problematic situation, then she is entitled to claim the back maintenance, the arrears of maintenance as well. So the maintenance started accruing when the date the case is filed, not from where when the maintenance is actually awarded. So that becomes a very interesting point. So the rights of maintenance come from the personal law. Obviously, the position in personal law is different. The position of women as per Hindu law is a bit stronger than the position of women in Muslim law. Muslim law, the nafaka, the concept of maintenance in nafaka, it does not give parity the angle, but it provides that the husband is obligated to maintain his wife. How much maintenance is not very clear, but nonetheless, the secular jurisprudence on maintenance prevails over personal law. So even if a Muslim woman goes to the court under CRPC, let's say, she can claim an equal amount of maintenance. That is a very interesting aspect of it. Okay. So I hope everybody is with me till now. And third, I am coming because we have to keep some time for question and answers. So I'll straight away come to the third and very interesting aspect of protection of women from domestic violence. Now, this particular legislation was enacted in furtherance of our international commitment as well. So there is a particular theme called CEDAW. CEDAW is Convention on Elimination of All Forms of Discrimination Against Women. That is the CEDAW Convention. It's a very interesting convention that is there. And in furtherance of that convention, we enacted multiple legislation. We see sexual harassment at workplace is also in furtherance of that. One of this legislation, protection of protection of women from domestic violence act. This legislation is very deceptive, and there is a huge lack of awareness amongst the people about it. See, when we talk about protection of domestic violence act, apparently it looks like a criminal legislation that it will protect from domestic violence. Now, violence is the term which itself signifies that there is some criminal law angle to it. But the answer is no. Nobody goes to jail under Domestic Violence Act unless and until they are not complying with the orders of the court. Nobody goes to jail. It's a very remedy-based law. When I say it's a remedy-based law, it protects the rights of the woman immediately. It is intended to give speedy and effective relief to a woman who is in a domestic relationship. Now, domestic relationship has again a very, very wide angle. The term domestic relationship is a very, very wide angle. Like, it protects women who are in a living relationship akin to marriage. All other rights, the cruelty under criminal law, dowry, and everything that proportional law, they only come only after the idea of marriage, the emotion, the fact of marriage is established. Here it protects women who is in a domestic relationship, in a domestic relationship in nature of marriage as well. In the Veli Swami and Pachiyammal case, the Supreme Court deliberately very clearly said that if there is a long cohabitation, then obviously the right of the woman gets solidified. She gets a right to actually claim the maintenance from her living partner as well. So this is see how beneficial this legislation becomes. Secondly, it not only protects women in domestic relationship only in case of husband and wife. It protects a woman. It protects a woman in against her father, against her brother, against her grandfather, son, grandson, whatsoever be the case. Anyone, or not only women. Actually, when the Domestic Violence Act was enacted, the term respondent, or against whom a case of domestic violence against can be filed, included only male and only major male, adult male. This particular definition was very problematic. So that's why in Hiral Mehta versus the state, Supreme Court said, no, this is problematic. This is not something that is proper, because it is not at all true that a woman is subjected to domestic violence or any kind of mistreatment only from the her male relatives. Female relatives, they equally inflict many kinds of pain on another woman. It's very true. It's a truth of society. We should never divorce ourselves from the truth. Truth is that equally, or I do not have any data to back it up, but nonetheless, there is significant amount of cases when a woman claims mistreatment from another woman in the family, mostly mother-in-law. It's infamous. This relationship between a mother-in-law and daughter-in-law is infamous, and it goes the other way around also. Many times, mother-in-law, they complain of mistreatment by the daughter-in-law. So that happens more often than not. So this particular definition of respondent, who can be the opposite party in a domestic violence case, the women relatives were also included. And the term domestic relationship is very wide. It is not that immediate relatives like husband or father or children are included. It includes also distant relatives. Suppose if a particular woman is living with her uncle, is living with her cousin, what's the case? Living in a joint family. In all those cases, a woman is protected from all other relatives who are related to her by blood marriage and adoption. Blood marriage, adoption, or marriage includes the relationship in nature of marriage. Everything is included. So a very wide definition is given to domestic relationship. So when a woman is in a domestic relationship and she faces any kind of domestic violence. Now, domestic violence again has a very broad notion. It includes physical mistreatment, it includes mental mistreatment, it includes trauma. Again, what I mentioned as financial cruelty, when she is not given financial autonomy. Any kind of pain is inflicted on her, mental, physical, financial, then that qualifies as domestic violence. And then it is entitlement of that particular woman herself is entitled to file a case. Then there is protection officers. The Act provides that there will be protection officers who will take care if she receives a report from not only that woman, but any person that a particular incident of domestic violence has happened. They will simply go and investigate that. They have an obligation to actually investigate or look into the matters of domestic violence, irrespective of whether the victim has approached them or not. If you will go to a police station and you will say, sir, mere pados mein there is a person who beats his wife, you do something. And then what do you have to do with it? The police will simply throw you away. Yeah, why you are becoming so concerned about it? Let them come. Let the victim come. But that is not the case in domestic protection of women from DV Act, domestic violence. That particular aspect is there that anybody. Now, I remember 10 years or back or so, there is a whole campaign, TV campaign. That campaign was called Ghanti Bajao, ring the bell. If you see an instance of domestic violence or any dispute you see, go and ring the bell. It means that everybody has a right to actually involve themselves in that particular dispute. You go and you tell a protection officer that this is happening. So they will go to that protection officer, have a duty to go, and they will register a DIR, what is called domestic incident report. That DIR is mandatory. Even if the woman is saying that I don't want to file a case. See, in a domestic relationship, the position of woman, many more often than not, is not so strong that she can resist or she can take the legal recourse. That's why people say that most of the cases in which domestic violence 498A cases are false or the dowry cases are false. Many cases might be false, but it does not. It is equally true that many cases that happen are not reported. Why it is not reported? Because the position of woman is not so strong in that particular matrimonial house that she can take the legal recourse. She has kids, she has a husband, she has no income of her own. She feels, okay, if I file a case, my husband throws me out, what will happen to me? I am sure you are all part of legal aid of law institutes. I believe you are all law professionals. You go to any village, you ask a woman, कि आपको आपका husband पीटता है, whether your husband hits you. She'll say yes. And you ask them next question, whether you are going to do anything about it. She will say no. 8 out of 10 cases you will find this answer. The wife will say, yes, my husband mistreats me, he drinks and he behaves very cruelly, my mother-in-law tortures me, whatever the case may be. But at the same time, you say, you want to do something about it? She says, no. Because where I will go? If the police comes and catches my husband, where I will go? That's a problem. That's a very real problem. Domestic Violence Act tries to provide some answers to it. Firstly, a domestic incident report, when it is lodged with the protection officer, matter goes to magistrate. Magistrate sees that matter, and even without the consent of that woman or even without the woman coming forward, there are 5 types of reliefs that can be granted. 5 types of protection are there to a woman. First protection that she has is obviously, and the most important, I believe this particular right is very, very important, and that is called a residence order. Residence order is a right of the woman not to be thrown out from her matrimonial home or any home that she lives, be it maternal home, paternal home. See, the most important, the biggest fear that a woman might have in a domestic relationship, what if the person throws me away? What if I'm kicked out of the house? Where I will go? I do not have any other place to live. So if I have to live under this roof, I will have to comply with the commands of this person, whosoever is inflicting domestic violence on her. She feels bound by that particular setup. So the first right she has and the first order or remedy that she can get from the magistrate in DV Act is what we call a residence order. Now, for getting a residence order, she need not have any right over that particular shared household. The term shared household is used. Shared household means wherever that woman is living with other family members with whom she is in domestic relationship. Means I'm living in a home with, let's say my husband has died, I'm a woman, my husband has died, I'm living with my in-laws. Now that house is not mine, that house is of in-laws. But nonetheless, I am living with them in a domestic relationship. So that house becomes shared household. So the first right that the magistrate will protect in respect of that woman is protecting her right to that particular house. Court will say under no circumstances she can be kicked out of that house. That's the brilliant relief. The moment she is thrown away, the police will come, will actually throw the other parties out of that house. That is the right. The court, while giving residence order, can also issue a protection order in which they can stipulate, the magistrate can write that if her possession or her accommodation is disturbed, the other members of the family can be asked to leave. That is the extent of the powers given to the magistrate in DVN. But that is a remedy that she has. That is a solid remedy that she has. She need not have any right over that household. Sometimes she lives with her husband while the house is in the name of the parents or house of the joint family. And she fears she'll be kicked out. The husband says, oh, it's my father's house, it's not my house that you will claim. It's not required that the house should be hers or her husband's. No. If she is living with any person, suppose a particular girl is living with her uncle, is living with her grandfather, whatever the case may be, she has a right to reside in that house. Her entitlement over the house will be decided in an eviction suit. If they want to kick her out, they will have to go to the court and file a suit of eviction. And that is a civil dispute that will drag on and on and on. But nonetheless, they cannot actually physically kick her out of the house, like we can do with a trespasser. Suppose that my house is there and somebody comes to my house and they do not have any right to be that house. I can kick that person physically. I can exercise my right to self-defense, or what we call right of self-help from the trespasser. But if a woman at any point have lived with a particular person in a domestic relationship, in a shared household, the woman cannot be kicked out by force. That is the first thing. Second is protection order. Protection order. A woman is entitled to get protection from all those who are inflicting physical pain on her. The magistrate can order that she should not be disturbed. She should not be talked to. Even a loose comment over her. ताना बांधना या फिर उनको चुभती भी बातें. You say something that is inflicting pain on her. All those things will be prohibited by the court. Court can simply enforce a no contact rule between the respondent, the opposite party against whom the case of domestic violence is registered. The court can say you will not interact with this woman. Let's come to the court. Absolutely no interaction. If you interact with her, then you have committed an offense, then you go to jail. That's an issue. She might be given a separate place for her accommodation in the shared household. No one will disturb her, no one will interact with her in any way. All those things are there. So that protection order is there. Nobody, obviously, if any physical violence is prohibited, any kind of mental cruelty, any kind of financial cruelty is prohibited. Then she has maintenance order. Obviously, the court can award the maintenance in order to ensure that she is financially stable. That maintenance order is also becomes very important. Getting maintenance under CRPC or getting under personal law again can be a issue. But under DV Act, the remedies are very quick and efficient. And obviously, the women need not fight that case herself. The entire matter will be handled by the protection officer. Like if you want to file a case in CRPC or personal law, you will have to have a lawyer who will represent you. That person might charge money. Obviously, the lawyers are not going to start going to the legal aid. Also becomes a difficult task. The legal aid, again, I will be very truthful, not very effective in our country, unfortunately. Not very effective, but nonetheless, the protection officer is the person who becomes nodal officer for everything. Protection officer will take care of all the proceedings. And again, I'll emphasize that even if someone doesn't want to be protected, the court will protect her nevertheless. A domestic incident report is filed, then the court can issue protection order or residence order or maintenance order, as the case may be, to protect the woman from destitution. And the right becomes secondary and the notion of protecting the woman becomes first. Yes. So in that case, the protection officer becomes very important person, the nodal officer. Obviously, somebody commented that yes, then a legal aid advocate is provided. All those things happen. But see, she herself need not to go to the advocate and her role, her burden is obviously uh, elevated by this particular arrangement. Yes. That being said, there are two more orders, two more remedies that are given to her. First is custody order. If she has a children, she can claim custody of those children in the DV Act, because this becomes a very potent tool in the hands of abusers, that they will withhold the access of the woman to her children. Okay, you will not be allowed to be with the children. If you are, you were, wherever you are, want to go, you go, but the children will stay with me. This is my child. This particular notion is there. So this particular problem comes time and again, that a woman's access to her children is restricted. Now that is something that the law will protect. The law simply states, the DV Act has custody orders, that even before the matter goes to a family court to decide the custody of the woman, custody of the children, a woman can get custody order under DV Act. That's a speedy remedy. Custody battles in the family courts are a long drawn battle. It takes a lot of time, takes a lot of money, advocates. It's a paradise for the matrimonial lawyers. But nonetheless, DV Act, speedy remedy, very quick, very effective remedy. And fifthly is the compensation, the monetary order, or what we call order for the compensation for her whatever pain she has suffered, damage. See, the jurisprudence of compensation is there, generally not there in the domestic setup. In a family, husband asking compensation from the husband is something that has been unheard of, because there is a notion civil law, husband and wife are one unit, so they cannot sue each other for torts, for personal injuries as such, in common law. Similarly, in family law, there is no idea of compensation. There is alimony, there is maintenance, but there is no compensation for the harm she has suffered. But Domestic Violence Act is a beautiful legislation in that aspect. The court can award, the magistrate can award compensation to that woman for whatever pain she has suffered, for her loss of earning. Suppose if she was compelled not to work, her earning was disrupted. In that case, she can get that money as a compensation, whatever physical or mental damage she suffered, whatever medical expenses she made, whatever money she gives, whatever money she has spent on therapy session, everything she is entitled to claim as maintenance. So again, it becomes a very interesting tool, very important tool in the hands of that particular woman who is abused in a domestic relationship. She can claim compensation. The idea of compensation becomes very important. So these 5 kinds of remedies are there in DVI. People are not much aware about it. They feel very strange dealing with these matters. The feeling is very, I'll say, they do not understand the true purpose of this legislation. Neither the advocates understand, nor should be the first remedy that a person should seek. Because the remedy is the quickest, and not, there is also, because the remedies are not very solid or final, so it might not have the same tragic impact on relationship that other type of cases might have. So, why against husband or the police will come harass the husband, and suppose there was a chance of settlement of the of reconciliation among parties, that becomes absolutely impossible. And that becomes code. But action order of the DV, it is not that damaging. It will have interest, and matter will be in a way. So there is always scope of reconciliation. So I believe the remedy that is there under the DV Act is much more effective, and I believe it is not being used to its full extent, but I believe it should be. So these 3 types of remedies are available to a woman who is in a domestic relationship. And now I request anybody has any questions, they might go ahead. I'll Some of the questions I have received, I'll try and answer that. Yes, it says that the court gives the residence and maintenance order in every response. Yes, in generally the first order that they give is protection order. First order that they give is protection order. And if the court feels that okay, residence order is required, suppose the woman, the wife is living in her own house, she has a right to. So she's not threatened. Another question. Okay, one second. Yes, I have received a question. Somebody, yes. They ask that Indian society has rooted cultural and patriarchal norms, often conflict with the progressive legal framework such as DVM. How can law harmoniously work with this cultural framework to promote women's rights and the family? See, equality in marriage definitely will increase some disputes. See, whether we want to keep it hush hush or whether we want to take it to the court, that is a conscious decision one has to make. See, I've been teaching learning and family law and teaching family law for the last 10 years or so. I have one very important observation. That observation is that education and empowerment of women is directly proportional to increase in the matters related to divorce and breaking of the family. Because the more empowered the woman, it is less likely that she will meekly take the abuse and violence from her husband or in-laws. The more independent she becomes, there is a possibility the more assertive she becomes. There is a possibility that the divorce cases or the family breaks sometimes when the it is not possible for the two people to live harmoniously in proper way. Then obviously family breaks. But to drag on a dead marriage is way more painful than facing some kind of social stigma. If person is in an unhappy marriage, I have seen people who were very happy, very productive, just because they are in an unhappy marriage, their productivity, mental sanity, everything is destroyed. If they're in an unhappy marriage, everything that they hold dear becomes very problematic. So, as far as possible, people should try to conserve the family, but never at the expense of abuse. A woman should not tolerate abuse, even if she's called anti-family or whatever the case, whatever the people say, society will eventually accept. Our society is changing. I believe it's changing very rapidly, and the society is accepting these types of progressive norms very speedily. Now the daughters are claiming property from their property of the father, which was unheard of 50 years back. But it's a slow and steady process. If we'll try to thrust it down the throat of society, that is also not proper. There's no need of a revolution that will take out a march, and we will have to simply spread awareness. Society will take its own course. The more women are educated, the more women become part of the workforce, the more empowered they become, the more they develop of rational thinking, these laws will become more effective over the period of time. The effectiveness of law is simply correlated with the awareness of the society. If the society is aware, the law will become effective over a period of time. So obviously, it's a deep-rooted cultural and patriarchal, but the reform is going on. The reforms is not a sudden process. We cannot make it simply one day will reform everything. No, it's a very slow and steady process. The process of reformation in the family, Ishwar and Vidyasagar, Ram Mohan Rai, everywhere they have done their bit. We are doing our bit. Our future generations will their own bit. And one day, I believe we are moving in the right direction, and we'll have to balance the interest of the society, interest of the family, as well as the interest of the individual. Some adjustments are needed in the family. We should not be very temperamental or we should not be very short-sighted. But to be in an unhappy marriage where the partner is abusive or unfaithful, I believe there is no higher pain than that. There's no greater pain than being in a relationship with an abusive or an unfaithful partner. So sometimes it is better to approach the court for legal remedies. Yes, any other questions you might have?
Sir, I think there were some questions in the chat box that maybe you can address.
No, actually, I think I discussed all the questions that were in the chat box. Any other questions you might unmute and you can speak or write in the chat box as convenient as you might feel convenient. If not, then I thank the team of Legal Voice for having me here.
Thank you so much, sir. And if anyone has a question, we'll wait for the next 1 or 2 minutes and then we'll move on.
Hello, sir. Good afternoon, sir.
Yes, please go ahead.
Sir, if the husband and wife are living in a rented house,
Yes.
so if the wife faces domestic violence, so how the right to residence will decide, sir?
That's a very interesting question. See, there is simple logic that in a rented house, the husband has no title, obviously, in that property. But nonetheless, the court, while issuing a residence order, may compel the husband to keep paying on the rent of that house. The husband, while till the husband has rented that premise, wife will be given residence order. So, in order to defeat an order, what husband can do? Husband can simply terminate the lease. He can say, "I'm moving out," and he can hand over the possession. He can try to hand over the possession to the property owner, to the landlord. So what the remedies, what the courts actually do, they compel the husband to keep paying on the rent of that property. So that is something I have known the courts are doing. So that's what we can do. But definitely, if the lease actually expires, if no such order is there, then the wife cannot have any claim on that property. The residence order cannot be given in respect of rented premise after the lease has been concluded. If the lease is over, there can be no residence order because the right of that landlord is also very important. But if the lease is subsisting and the husband is not paying the rent and thereby the wife will face eviction, uh, they will face eviction, the wife will face eviction because of that. In that case, the court can compel the husband to keep paying on the rent if the lease is not concluded automatically.
Okay, sir. Thank you so much, sir. It was a very great.
Now, yes, she can. Those who are in domestic relationship need not be related to by blood only. It can be by marriage, or by marriage you are not only related to your husband, you are also related to your in-laws. So maintenance, actually the right of maintenance does not flow from sister-in-law, because there is no right, there is no duty of a sister-in-law to maintain her sister-in-law. So in that case, maintenance do not believe can be claimed, but compensation can definitely be claimed. If a sister-in-law has subjected a woman to a wife, a woman in a matrimonial home, she has been subjected to cruelty by her sister-in-law, then the sister-in-law can be compelled to provide maintenance to her. So right of not maintenance, sorry, compensation. Sorry, so much. My apologies. The compensation can flow from her. There is no problem. But because there is no duty to maintain, so maintenance order I do not believe can be awarded against the sister-in-law. But the compensation can be definitely be there. If you have another question, it's okay. Ridhima asks how the court register recognize taunts as a daughter-in-laws. Yes, this is a very interesting question. How you can prove the mental cruelty she is living in the shared household. How you will protect her from the other members of the family. In those cases, see, it's very important to understand that the court generally accepts the evidence or gives credibility to the evidence given by the woman who has been abused. If she says, the presumption is that she's saying the truth, and the other parties will have a reverse burden of proof. There is a reverse burden of proof on the other parties. That's why I have maintained no interaction, no contact. Nowadays, it is even simpler. We all have recording device with us at all point of time. Whatever some person say, we can record, we can click picture, we can make a video. So nowadays, it has become way more simple. But definitely the court can enforce a no contact policy. The court has a right to, magistrate can order that the area or the room or the place or the part of the shared household in which that particular protected woman lives, nobody will go in that particular direction. No one will interact with her. In order to enforce that, I believe the credibility of that battered woman or woman who is being abused or who is protected by law, her evidence is considered credible unless proven otherwise. Okay, so I believe there is no other questions. If there are no other questions, then I again thank Hemanji and Abhinavji for having me here. I believe all I have somehow helped your understanding in this matter. So thank you so much for having me. It's always a pleasure being a part of a legal voice session.
Thank
Thank
you so
you.
much, sir. And I believe it is your third or the fourth session. And whenever I sit and think that what do I write for a thank you note, I think to myself that how do you thank someone who is the existence, who is the reason why your organization exists? But then the
Thank
but then the formal nature of these events does not allow me to do away with the thank you note. So
so
thank
need
you so much.
responsibility. Absolutely, it's my pleasure.
Thank you so
Interacting with
much.
students. People say get a life. So my life is only interacting with young, brilliant legal minds. So thank you so much for having. It is an
We
absolute
can
pleasure.
we can absolutely vouch for that, sir. Thank you so much for your insightful participation and your expertise and valuable contributions have greatly enriched the event. We would
Thank you.
also just like to point out to the participants that the next event, which was supposed to be at 5 p.m., has been rescheduled to 7 p.m. owing to Dr. Garima's obligations. And while the third session will happen on its scheduled time, which is 6. So please join in. Okay. Thank you so much.